the person who has been physically removed from the United States will have two challenges, okay, to come back. The first one is the post-departure bar. So once a person has been physically removed from the United States and they're actually now living in their country of origin, well, there's a post-departure bar that is attached to their order of removal. In some states, that person will face a challenge when the person is trying to reopen their case, because the judge will claim that they don't have jurisdiction over that case and therefore they cannot reopen that case. The second challenge is the fact that the person has been ordered removed. Technically, the person has either 10 years bar, 5 years bar, 20 years bar, or a permanent bar, depending of the circumstances, right? Some people, most of the time, it's a 10 years bar that is attached to an order of removal coming from an immigration judge. So this is a case where I'm trying to answer that question, right? So because we're doing the series of how does ICE carries out the removal order. So this is a case where the person was already ordered removed and finally applies for a U visa. And while they were trying to get their fingerprint taken, they got detained. Of course, arrested by us, detained. Somebody called ICE anyway. So they got arrested, detained, placed into ICE custody. Then ICE arranged for transportation, and that person was physically removed to their country. So the question becomes, how am I going to come back? Well, two things. First, if you are in a circuit where there's a post-departure bar, you're not going to be able to reopen the case once the application is granted. So basically, the U visa was finally granted, and the motion to reopen was denied because of post-departure bar, especially in the Third Circuit, right? Some circuit it might work, but in the Third Circuit, it's a big no. So then, what else can I do? Because now the motion to reopen the case has been denied. Well, now you're gonna have to try to apply for the form I-212, permission to reapply. If it's granted, then you're gonna have to apply again I-601 for some type of inadmissibility issue, depending on the reason why the person was removed, right? So once those two forms are granted, then the person can apply for another visa, non-immigrant visa, or the green card if the visa is available. So basically, where we are at this moment, we are trying to apply. We did apply for the form I-212 and I-601, waiver of inadmissibility. So we're just waiting for those two forms to be approved so that the person can apply for a visa to come back. It's really hard when the person has been physically removed. So to come back, it just depends on, it's case-by-case basis, depending on the circumstances, what type of bar is attached. If you've been waiting for 5 years or more, you can try with those waiver and see if it's going to get granted. Or if you wait for the entire 10 years, then you don't need the waiver anymore, because the 10 years bar is already lapsed, right? Unless you need waiver for other inadmissibility grounds. Other than that, you just, if the 10 years has lapsed, then you can just apply for a visa if the visa is available, if the immigrant visa is available, or if you can apply for a non-immigrant visa. So this is the answer we're trying to answer about that specific question, okay? So we're going to be doing a lot of videos. Just please share, please like. Until next time, bye-bye.